So hello everyone, and also thank you, Trisha and Joris, for inviting me to present some of my ongoing research. As a matter of fact, what I tried to do with this presentation is combine a number of things that I've been working on in the past few years, as well as give a bit of a teaser, I guess, of this 3-year research project that I'll be embarking in September only, which gives me the excuse to not have all of the answers at the end during the Q&A. But also when I drafted the abstract for this talk, I thought all of this was perfectly doable, but while putting together my slides, I realized that it might have been a bit too ambitious. So as a disclaimer, I also want to say, forgive me if I'm going a bit too fast on certain points, but I'm happy to follow up in the Q&A or via email. I have a bunch of hidden slides that I didn't want to bore you with during the actual presentation, but maybe I'll bring them up during the Q&A. All right, so in this presentation, I'll be talking more conceptually about the role of the law in enabling transparency and data access, specifically in the context of platform governance. And before that, I do briefly want to talk about the reason why we're talking about this in the first place. So what's the urgency? And to me, this can be pretty much reduced to one word: observability, and the ability for an engaged civil society, in a broad sense, from academia to investigative journalists, to NGOs, the media, the public at large. So for them to observe the world and critically engage with it. And today we see that these digital infrastructures are increasingly forming this intermediate layer between ourselves, each other, and our environment. And this, of course, constitutes both an opportunity, but also a challenge for investigative research. The data that is generated, either as the goal or the byproduct of these digital infrastructures, may feed into countless research goals. And from studying infrastructures, for instance, exploring how the real-time bidding industry really works, to studying impacts, for instance, the social and psychological impact of content moderation, to studying, well, basically anything else. And I don't mean to be flippant about this. I think this is an often overlooked item in platform transparency debates, which often tend to focus on transparency for accountability's sake. I think it's quite important to also stress the huge value of repurposing platform data for research that does not directly relate to the platform per se. So clearly there's all of this potential for using platform data for all kinds of research projects. But of course, there's some significant challenges that we face. And for my purposes here, I identify 3 main challenges: complexification, concentration, and privatization of digital infrastructures and data. And in response to these challenges, researchers have developed all kinds of methods and approaches to obtain relevant data nonetheless in the past few years or decades even. And in a way, sort of to try and make sense of all of these different approaches, we can make roughly 2 key distinctions: collaborative versus adversarial approaches, and top-down versus bottom-up approaches. What do I mean with that? Well, the first distinction sort of relates to the relationship between the company, the private actor, and the individual, the researcher. Top-down versus bottom-up approaches, this sort of refers to the point of access. Where is the data coming from? Either from the private actor or from the individuals, the endpoints, if you will. I've added some examples to the table. I don't have time to go into detail on them, but I would think they're pretty straightforward. Obviously, all 4 categories in this table have their own pros and cons. Top-down approaches give this holistic perspective often of the entire ecosystem, but on the other hand, often lack granularity. That's something that bottom-up approaches can give. They can give that granularity, but often then they raise like representativeness issues. And then collaborative approaches, they may be quite productive. Think of social science 1, actually come to think of it, it might not be the best example, but like ideally it would have been a good example. But of course, these collaborative approaches where researchers closely work together with platforms raise a lot of independence questions and might also solidify problematic power dynamics, both in the private sector as well as in academia. And so I think for the rest of my talk, I want to focus on these adversarial approaches that I think are particularly valuable in these environments, in these contexts that are characterized by strong disincentives to share data in the first place. And what I want to do more specifically is position the law as such an adversarial approach in researchers' investigative toolbox, both top-down, through disclosure requirements and transparency obligations, as well as bottom up through individual access rights. All right, so let's have a closer look at both of these approaches. So starting with the first one, disclosure requirements. This is a red thread throughout the proposed Digital Services Act with all kinds of disclosure requirements regarding platform operations, mainly in Chapter 3 of the DSA. I'm not going to go through all of these provisions, just to illustrate, you know, it's definitely a red thread throughout. Now, taking a step back, however, one can find similar types of disclosure requirements, transparency obligations in many different legal frameworks that pre-exist, you know, this proposal for a DSA. And that's also why last year, in the run-up to the drafting of the DSA, I wrote this report with my colleagues Paddy Learson and Pim Tuntay for Algorithm Watch, where we looked at what can be learned from these existing frameworks. So we don't have to reinvent the wheel. Specifically, so, you know, to feed into these debates on platform transparency. And so in our selection of relevant legal frameworks, we focused on two specific issues that are quite prevalent in the platform context. And we call them the incentive problem. So how do you force meaningful transparency from actors that have a strong disincentive to share information in the first place? And these disincentives can be legal, economic, or technical. And GDPR concerns. How do you enable meaningful data access to information that is highly sensitive? And so the two use cases in this report focus on environmental protection law, which puts in place quite strict transparency rules for pollutant industry actors. And GDPR concerns, we looked at the medical research context, where very sensitive personal information is shared for research purposes. And so we thought, you know, if it works for medical data, it sure as hell should work for social media data, for instance. Anyway, I don't have time to go through the analysis here, obviously, but I've listed the main best practices that we drew from these case studies here. And of course, the report is also available online. Maybe I'll just highlight 3 best practices. So for instance, to counter the incentive problem, I've highlighted, you know, standardized methods for data generation will be quite important, you know, learning from this environmental protection debate or framework. There's quite some literature also in defining, you know, like specific methods, you know, are we like, is the data generation based on measurement, on calculation, on estimation, and to what extent do we need defined methods for each of these? And of course, in the platform context, this can be further developed in sector-specific codes. To overcome sort of data protection concerns, it'll be important, at least in our opinion, you know, to work with a request-based adaptive regime, and that's demand-driven and purpose-based, where data access is really assessed and provided on a case-by-case basis. And then finally, this last box is our sort of cross-cutting best practices. So proactive support for researchers is quite vital. It's not enough to simply make available data. It's important to actively cultivate this robust environment for investigative research. And this can happen perhaps most straightforwardly through funding, research funding, but also by providing technical support and so on. All right, so let's have a closer look now at these bottom-up adversarial approaches. And the main legal tool here can be found in a framework that many social scientists do not generally have a positive response to. Of course, I'm talking to talking about the GDPR, and in particular, Article 15 of the GDPR, the so-called right of access. A right, mind you, that has existed in national and European data protection laws since at least the 70s. Right? So it's now also incorporated in the EU's Charter of Fundamental Rights. And so just to make clear that it's anchored pretty deeply in the legal framework. Now, what does this right enable? Why does it present so much potential for researchers? There's many reasons. I've listed a couple of them on this slide. So first of all, this provision gives individuals the right to obtain all of their personal data. And it's important to stress for the non-lawyers or the non-GDPR experts in this call that personal data is interpreted very broadly. So it's not just your profile picture and your email address. It also includes inferred data, derived data, and so on. And that's not even all, right? Article 15 also gives you the ability to obtain access to metadata, if you will, the information surrounding the processing of your personal data, such as how long has it been stored for, who has it been shared with, where does it come from, and so on. The right is intent agnostic. You cannot be asked by the data controller, the private actor, to motivate your request. They can also not charge you a fee for exercising this right. And you should receive a response within maximum 1 month's time. The response should also be provided through electronic means where possible, and in some cases also be machine readable. Obviously, these are quite relevant points for researchers. And the idea is then, that these rights, right of access is crowdsourced with research subjects. Now, of course, there's many more nuances and elements to this. And so for people that are interested in it, I'd recommend reading this paper that just came out a couple months ago that I wrote with Michael Veal, Researching with Data Rights in Technology and Regulation. So use your search engine of choice to find this paper, or otherwise just send me an email. Okay, so to conclude, what is the outlook for data access in the platform context now? Sure, it appears that a lot can be learned from existing legal frameworks on how to operationalize meaningful transparency. And the right of access in the GDPR offers a clear and powerful legal tool that can be deployed by researchers right now already. But of course, a lot of open questions or action points, if you will, remain. And I've listed a couple of them. Of course, this is not an exhaustive list on this slide. First of all, meta transparency, being transparent about being transparent. And in order to ensure trust and accountability in the data access regime itself, that regime itself should also be subject to transparency safeguards. It should be clear how data was generated, for example. Liability for disclosed data. This is quite important in light of strong disincentives to share data in the first place, what I said before. But also requires careful attention and should be clearly laid out in light of the powerful incentives that a strict liability regime will generate. So you don't want excessive liability, neither do you want excessive immunities. So one idea that we can draw from the environmental protection sphere is liability for completeness and the consistency of data disclosure, for instance. And of course, it comes back to the age-old question of enforcement. But that's yet, and that could be another bullet point to this list. Being clear about what we want. Well, may seem obvious, but it's quite a thorny issue nonetheless. It's the most often returning question when I'm talking to social scientists. What data are we talking about? And this is a very hard question to answer in the abstract, because platforms are active in a constantly growing range of economic and social fields. So the types of data that we may want access to will depend on the type of phenomenon that we want to study. So how do we determine this scope of data? At the very least, what I want to warn about, what I want to stress is to not focus exclusively on transparency with just the goal of holding platforms accountable alone. There's much more dormant potential there. Proactive versus reactive disclosure. What do I mean there? Well, in the question basically of should information be published proactively? For instance, in the Facebook's ad archive would be an example there in an online database, or should it only be released upon a specific request? You can also think of the debate in open government, of open data versus freedom of information requests. Both obviously have significant pros and cons. So it's really important to think through what the best approach is here, and arguably or presumably rather the solution will be somewhere in the middle, a combination of both. But where that line is definitely something that should be looked at more closely. Fifth, legal, ethical, and methodological considerations. Again, it's quite obvious, but nonetheless important to stress. Using legal tools for obtaining data raises a set of particular challenges for researchers and the research community more broadly. And this is something, again, that needs further attention. We take a first stab, Michael Veal and I, in the paper I mentioned before, at sort of naming some of these issues and offering potential, solutions. And then finally, technical infrastructures. These will play a vital role in enabling and scaling the use of these legal tools for data access. I'm thinking in particular of secure processing environments, a notion that is mentioned in the Data Governance Act, but also in several legal frameworks before that, and also data donation platforms. So some of my colleagues here at the University of Amsterdam, for example, are in the process of developing this proof of concept of such a data donation platform, which is specifically designed, to make it easy for research subjects to submit their data download packages, the information that you get when you click download my data on Google or Facebook or Twitter or whatever. And then have the ability as an individual, to pre-select what data you want or not want to be shared with the researchers, and with built-in, pseudonymization and anonymization tools before that information is then shared with the actual researchers. So these types of tools will certainly also be relevant, in order to make data research more scalable and useful for the academic community. So I think I'll leave it at that for now, but looking forward to the debate. Thank you.